Welcome to dBrief. I, Deepika, will take you through the highlights of the webinar, 13th Medicolegal Webinar Series, which was recently organized by IMA-MS Medicolegal Cell on 23rd October 2020 and sponsored by DigiShield. In continuation of the previous webinars conducted by Medicolegal Cell, DigiShield, in association with IMA-MS Medicolegal Cell, organized the webinars to make the doctors aware of their rights as well as legal laws which apply to each situation. The session mainly focused on sexual assaults and the deeds of the doctors. To encounter such a sensitive case calls for certain immediate actions on the parts of the doctor. Here, with an interactive session, the entire concept was shared in depth and cleared all the doubts if any. The session was kick-started by Dr. Nikhil D. Dattar, who is consultant gynecologist and medical director of Cloud9 Group of Hospitals, Mumbai. Began to address his chosen topic, dealing with the case of sexual assaults, what doctors should know. He shared that a sexual assault in an ordeal for both doctor and victim where the patient fears to file an FIR. He explained in detail the SAFE project and laid down the different laws which come along with it. Along with different case studies, he described the complexity and provided the right solution for the same. Let's get a gist from him.
Now, it is absolutely mandatory that there should be no police personnel in the room of examination. So even if it's a female police personnel, you are not going to allow. Of course, you will require a female attendant, but a female police officer cannot be an attendant for such kind of an examination. After the examination, you must allow her to wash herself. And last and most important thing is that the hospital is expected to provide for the clothes, because if she has submitted the clothes, and usually the clothes will get submitted for the purpose of examination. In our series of cases that we have found in those days, this is before the protocol came into the picture by the ministry, we used to have a situation that the woman comes, you want her to examine and you want her to submit her clothes for evidence collection, and they may be very, very vital pieces of evidence, because there might be hair, there might be semen on that particular clothing that she is wearing. But then what will that woman wear if at all you want to send her home? Because there was no provision of giving any clothes to that kind of a woman in a government setup. So this is going to be very mandatory in terms of helping the cause of justice that is involved.
Dr. Ashok Shukla, who is a gynecologist and medico-legal expert in Sai Ashirwad Maternity and Nursing Home, started to speak on the topic Protection of Children from Sexual Offences Act 2012 and 2019. He warned every doctor by suggesting the crisis of the problem as well as the facts, which are also quite alarming. He began by sharing some statistics which indicated that 1 out of every 10 women reports some kind of child sexual abuse. The laws were discussed in detail by him, along with their implications. He concluded by suggesting some of the important tips. Let's know it from him.
So as I told you, first the mother, guardian or relative should be there. Specifically, a lot of time in pediatrician, family physician and dentist. Sometimes a girl comes who's 9-year-old accompanied by the brother who is 11-year-old or 13-year-old. See, both are minors. Be more careful, because see, they might not understand why you are doing a particular thing. For example, you are giving injection on a hip distance, or it's slightly obese and your finger just slightly tilted. The mother, the girl child or the boy will tell the doctor touched here and then gave the injection here, and they will misinterpret ki I was not there and why doctor did this way. CCTV is good, but you can't keep the CCTV everywhere. In the examination room specifically you can't keep, but in the passage and the outer part you can keep, because there are different issues where in NICU or pediatric ICU, where a girl child is admitted, a boy, a ward boy or RMO goes and visits at an odd time, examines, again becomes a problem. So even when you are taking around, see that a female staff or nurse is there. If you are going and taking rounds also, it is to be there, because you might be touching the patient, which patient might misinterpret. So always there. So this becomes very important, as I have showed this.
Up next, we have Mr. Jahangir Gai, who is a senior consumer activist. began to share his knowledge on the topic Right to Information Act and issues related to the medical fraternity. He explained the act in detail and also explained the definition of public authority. For a better understanding of the same, he shared certain case studies and discussed in detail the technicalities. To conclude, he said,
Doctors are not public authorities. A private medical practitioner is not designated as a public information officer under the Right to Information Act. The details of the treatment given by a doctor to a patient are confidential in nature, and the medical record is held in fiduciary capacity, where the patient has trusted the doctor with his personal and private information. So in view of this, the RTI Act is not applicable to medical professionals. If at all, a record has to be submitted only to a government agency which has the authority to call for a record, and that authority would not be under the RTI Act. It would be by virtue of some other law which empowers the agency to exercise control over the hospital or medical professional. So what should you do if you receive an RTI application? You would have a choice. Just ignore the application, or you can send a reply stating that the RTI is not applicable to you. The choice is yours. But please remember, it should set up your antennae. The moment you get an RTI application, you must be alert that something is brewing. So simply do not tear and throw up the application saying it's not applicable. Retain it in your file and take extra care to preserve the medical record just in case some legal issue might crop up in the future.
Advocate Parvez M. Rustam Khan, who is practicing law since 1984, began to speak on the topic Will Medico-Legal Issues Faced by Private Practitioners. He started by sharing who all can make a will and how not all the wills are considered as valid. He suggested that to make a will, there should be an executive. To know his conclusion,
when a person is mentally ill also or is suffering from some kind of illness, but during the period that person is lucid, that person is able to think, then he is capable of making the will. Again, I would repeat, if you are obliging someone, then please speak to their physicians, please speak to their psychiatrists, please speak to whoever doctor is treating them. Preferably that doctor should sign rather than you signing it. But if he or she is your patient and you know the history and you are satisfied, please go ahead and do it. There is nothing wrong. Where the courts have said for such instances, the language is, the law does not require every testator to be in peak physical and mental condition, or to be possessed of sound and disposing mind and memory in the highest degree, so long as the testator has enough to discern, that means to see or notice without difficulty, and directly to judge the matters, that enters into a rational, fair, and just testament, that is surely enough.
Mr. Dipen Mehta, a COO, DigiShield, took the chair where he discussed in detail how DigiShield is enabling doctors to safely and securely practice these testing times of COVID-19. DigiShield can conduct a quick and effective COVID-19 carrier risk screening of every patient before visiting clinics. To watch the entire video, please visit our website www.digishield.me and click on the dBrief menu.